he has a lawyer who has created his niche within a short time. As they say, there's a lot of competition in the top, at the bottom, but you are lonely at the top. But at the lonely, while being on the top, while showing knowledge, you can always attract people, and that is one of the hallmark of Mr. Deepak, who can draw people with his knowledge, the way he can attract. And without taking much time, I will ask Mr. Deepak to give the insights on the topic, which is very relevant for the correlated with the Independence Day, that is 73 years of Indian secularism, a snapshot. I am quite sacrosanct that we are saying a snapshot, but it will be a shot which will be reminded for all times to come. Over to you, Mr. Deepak.
Namaste to everyone. And, I wish everyone a happy Independence Day. And I'm thankful to the organizers, especially Mr. Vikas Chatrat, for having taken the time out of his busy schedule to organize this particular talk and to constantly follow up with me to ensure that this talk is a success and it has maximum attendance.
Mr. Deepak, could you just put it back because your face is not coming full throat? Yes, now it's fine.
It's better? Yeah, okay. So let me just state at the outset why I believe that this particular topic is extremely relevant on this day. Because I think the issue of secularism has occupied center stage in Indian political discourse for a very long time. And for the foreseeable future, I don't see that particular issue dying down. And all sorts of opinions, either based on personal opinions or let's say an uninformed reading of the Constitution or its history, or the history of secularism itself is something that I get to hear on a regular basis. I'm not saying that every opinion is necessarily uninformed, but I do believe that a lot of personal opinions are passed off as let's say, opinions based on facts or expert opinions. And I'm trying to effectively give people access to first-hand sources, first-hand information, and at least try and introduce them to the roots of this particular topic so that they're in a position to form their own opinions and draw their own conclusions based on the sources that I wish to share with them. I do believe that it would be a mistake to discuss the issue of secularism in the Indian context purely from the standpoint of the Constituent Assembly debates or from the history of the Indian Constitution without understanding the origins of this particular concept outside of India. Because obviously this particular term and the concept as applied to India doesn't have strictly Indian origins. It comes from outside India the way it has been applied in India for a very long time. In this regard, I would actually recommend a fantastic book written by Professor Jacob D. Roever, and the title of the book is Europe, India and the Limits of Secularism. And this is a fantastic book that was published by the Oxford University Press in May 2016. And this book, according to me, sets out a fantastic history of what we understand as secularism and its Christian origins. So my reading of this book and my reading of other literature effectively tells me that India has accepted this concept of separation of the church and the state without ever asking itself, why does this phrase always translate to separation of the church from the state? In fact, that very phrase contains a lot of meaning and it points to a lot of history, because obviously a discussion around the separation of the church and the state is meant to point to, let's say, discussions around Christian theology and its impact on European nation states. Okay, that is the specific historical backdrop in light of which this particular concept of secularism must be understood. So for the longest of time, we are aware that in the Middle Ages, so to speak, or what is known as the Dark Ages of Europe, Europe was effectively under the control of the Pope. And at some stage around the 16th century, thanks to the concept, the Treaty of Westphalia, the concept of nation states started coming about. And these nation states effectively wanted to establish their own independent sovereignty away from the, let's say, the papal regime or under the influence of the Pope or the Vatican influence, so to speak. And which is why they decided that they need two things. One is that they need to recognize that nation states have the right to exist independent of the Catholic Church. That's point number one. Second, this particular development went hand in hand with what is known as the Protestant Reformation, wherein it was one of the things that the Reformation also brought about was the need to recognize certain rights to criticize the Pope as well as the Catholic Church, so that free speech is given effect to against people who don't believe, or let's say by people who don't believe in the concept of religion and whatnot. Three, the kings of nation states, and let's say of nation states or kingdoms, so to speak, decided to strike a distinction between those aspects of their public life where the Catholic Church would have some kind of influence, and those aspects of public life where the Catholic Church would have no influence. So that is the distinction between religious and secular that these Christian states and Christian princely states or Christian nation states decided to come out with. Okay. So the concept of separation of the church and the state was primarily, let's say, a kind of a social contract entered into between states which had a very clear Christian character in medieval Europe, so that they arrive at the territory division or subject matter division between the Catholic Church and the kingdom, or the king or the ruler, so to speak. This is why this doctrine of let's say, separation of the church and the state can never be divorced from the concept of Christian theology and the fact it has a very clear Christian identity. Okay. So if you read further, this particular history has been constantly corrupted over the decades, and people have effectively given the impression that European style secularism created the concept of a completely secular Europe, where no state has a religious identity, where no state has any form of allegiance to any church or any religious institution. Nothing could be further from the truth, because historically speaking and even contemporarily speaking, there are any number of European countries which have an avowedly Christian character, where the monarch is effectively the head of a specific church of a very specific denomination. Let's take two examples which are very, very popular, and yet for some reason people don't consider these examples when they talk of European secularism. The British monarch, the Queen, is effectively the head of the Anglican Church. Okay. And the Anglican Church is seen as the primary church of that particular country, and therefore they have a very clear denominational as well as religious tilt, which is recognized in their public life. Now, one other example which most people perhaps may not be aware of is that Scandinavian countries, especially countries like Sweden, which are typically cited as examples of progressivism or liberalism, or let's say extreme separation of church and the state, itself is a country that has a very clear Christian identity, recognized as part of its public life. And the monarch of that particular country, again, is associated with a very specific church. Then another example that we don't consider often is the example of Germany. In Germany, or in countries like Germany, what happens is the state recognizes two prominent institutions, namely a certain Catholic branch and a certain Protestant branch. And specific taxes in the form of religious taxes are collected from citizens who are members of these church. And certain specific social services are even delegated to these churches. So for instance, maintenance of a birth and death register, marriages, all kinds of relationships are effectively depended upon by the state on these religious institutions such as the Protestant Church and the Catholic Church. Now, when let's say Europe, which is effectively held as the example for secularism, follows this brand of secularism, where it clearly has public institutions which have a religious identity, and it also takes the help of religious institutions in providing certain public services and in the maintenance of national registers. Where does this notion of separation of church and state come about as far as India is concerned? How do we come to the conclusion? How have we arrived at this particular conclusion that secularism effectively translates to abolition of religion in public life? Secularism translates to abolition of imputation of a specific religious identity to the Indian state. And secularism effectively means that the state has to actively deny the role of religion, the existence of religion, and must treat itself as a godless entity. Whenever we have discussed secularism as far as the Indian context is concerned, we have conveniently adopted a policy of amnesia where we have dissociated the Christian origins and the Christian roots of the concept of secularism, and how we have blindly imported those principles without understanding what is its impact going to be on a land such as Bharat, especially in the backdrop of partition, and especially given the period of history that it saw between 780 until 1947, where several members of several communities were persecuted specifically for their religion. And this is something that was the subject of discussion, at least on two dates in the Constant Assembly debates. The first is 6th of December 1948. The second is the 15th of November 1948. These are two specific dates where the Constituent Assembly discussed this particular issue. And one of the proponents of, let's say, India not having a purely militaristic or, let's say, militant secular approach was Sri Lokanath Mishra. Sri Lokanath Mishra, I think, was the father of Sri Pinaki Mishra, who is the current MP from Odisha for Puri. And he's a member of the BJD. And he's also a leading senior advocate at the Supreme Court. So Mr. Lokanath Mishra has, if you look at his contributions to the discussions in the Constant Assembly debates, he was the one to specifically propose that Sanskrit must be introduced across the country as the primary language that binds people, apart from regional languages, so that people can understand the relationship between the native languages, their mother tongues, and Sanskrit, as opposed to mainstreaming English as the primary course of discussion between people. He was the one to specifically propose that let us recognize that finally the majority of this country is in a position to rule itself without any invader occupying it or without any colonizing power. Therefore, after thousands of years of suppression and of oppression, this particular community has finally arrived at a position where it can celebrate its religion, it can celebrate its culture. So let's not deny that particular opportunity altogether by imposing a certain militant brand of secularism, which we don't even understand in its full reality. So allow me to actually read certain portions of the Constant Assembly debate, especially portions where Sri Lokanath Mishra pointed out his position. Because if you read his position and his views, turns out that these views are still relevant today, and we are grappling with the very same issues and the very same mentality. So I'm reading out specifically from the Constant Assembly debate, volume 7, 6th of December 1948. And Sri Lokanath Mishra makes this submission. I'm not going to read out in entirety. I'm just giving certain portions to explain how even after 70 years or 73 years, we continue to deal with the very same issues. And we have not been able to make any headway because of a lack of honesty and let me say, lack of boldness in taking very clear positions on the question of religion and on the concept of secularism. Sri Lokanath Mishra, Orissa General. So this is what he says. Sir, it has been repeated to our ears that ours is a secular state. I accept this secularism in the sense that our state shall remain unconcerned with religion. And I thought the secular state of partitioned India was the maximum of generosity of a Hindu-dominated territory for its non-Hindu population. I did not, of course, know what exactly this secularism meant and how far the state intends to cover the life and manners of our people. To my mind, life cannot be compartmentalized, and yet I reconciled myself to this new cry. Gradually, it seems to me that our secular state is a slippery phrase, a device to bypass the ancient culture of the land. The absurdity of this position is now manifest in Articles 19 to 22 of the draft Constitution, which effectively translates to certain provisions of the current Constitution. Do we really believe that religion can be divorced from life, or is it our belief that in the midst of many religions, we cannot decide which one to accept? If religion is beyond the knowledge of the state or the ken of the state, let us clearly say so and delete all references to rights relating to religion. If we find it necessary, let us be brave enough and say what it should be. But this unjust generosity of tabooing religion and also making propagation of religion a fundamental right is somewhat uncanny and dangerous. Justice demands that the ancient faith and culture of the land should be given a fair deal, if not restored to its legitimate place after 1,000 years of suppression. And I'll read out a few more portions, since these are recorded aspects of history which form part of the Constant Assembly debates. If it offends people, I would request you to be mature enough to accept that these are facts. We have no quarrel with Christ or Muhammad, or what they saw and said. We have all respect for them. To my mind, Vedic culture excludes nothing. Every philosophy and culture has its place, but now the cry of religion is treated as a dangerous cry. It denominates, it divides, and encamps people to warring ways. In the present context, what can this word propagation in Article 19 mean? It can only mean paving the way for the complete annihilation of Hindu culture, the Hindu way of life and manners. Islam has declared its hostility to Hindu thought. Christianity has worked out the policy of peaceful penetration by the back door on the outskirts of our social life. This is because Hinduism did not accept barricades for its protection. Hinduism is an integrated vision and a philosophy of life and cosmos expressed in organized society to live that philosophy in peace and amity. But Hindu generosity has been misused in politics, and politics has overrun Hindu culture. Today, religion in India serves no higher purpose than collecting ignorance, poverty, and ambition under a banner that flies for fanaticism. The aim is political, for in the modern world, all is power politics, and the inner man is lost in this dust. Let everybody live as he thinks best, but let him not try to swell his numbers to demand the spoils of political warfare. Let us not raise the question of communal minorities anymore. It is a device to swallow the majority in the long run. This is intolerable and unjust. These are statements made by Sri Lokanath Mishra, an erudite member of the Constituent Assembly, as part of his submissions, questioning the meaning of secularism and questioning the definition of secularism and what is it that secularism is supposed to do with right to religion and right of propagation, and how do we safeguard the rights of even the majority of this particular country. So the point I'm trying to actually make is the very same argument made by Sri Lokanath Mishra in December 1948 continues to apply to several burning questions as far as Bharat is concerned even today. The simple question that I would ask myself is, if from 1949, or let's say from the 26th of January 1950 till the 42nd Amendment in 1976, which came into force in 1977, the word secular was absent in the preamble. Was Bharat any less secular? Were minorities ill-treated during that particular phase? Second, post the introduction of the word secular in the preamble through the 42nd Amendment in 1976, has religion not become the subject of political discourse and national discourse in an even greater fashion, where identity politics and specifically religious politics has become a part of Bharat's political life? The answer is a yes. Therefore, I believe that it's time that we revisited this notion of secularism, understood the impact of secularism on non-Christian states and non-Christian societies, understood how secularism has had an impact on stifling the expression of national life and let's say stifling the expression of civilizational identities. Let me raise one or two examples here to give you a better understanding of where I'm coming from. If you look at the motto of the Supreme Court and you look at the motto of High Courts, both of them are in Sanskrit. Okay. Similarly, if you look at CBSE schools or or schools run by the union government, Asatoma Sadgamaya is effectively chanted, and now that is the subject of a petition before the Supreme Court, citing secularism, saying this kind of an education also violates canons of secularism. Therefore, a land whose identity is influenced by a specific culture and by a specific civilization, it is being asked to forget the propagation of that particular culture and that particular civilization using this particular brand of secularism through legal means and through constitutional means, to basically say secularism under the constitution means that you must forget all your roots, you must forget all history. Some communities are effectively entitled to retain their history and retain the memory of their history, whereas other communities must effectively forget, particularly the majority community must forget, because if the majority community continues to celebrate its past and its history, it amounts to violation of secularism. This is effectively the sum and substance of the use of secularism as far as Bharat is concerned over the last 73 years. In fact, I would recommend people to read another book, a fantastic book written by this author, Sri Sandeep Balakrishna, and published by Indus University. The title of this particular book is 70 years of secularism, unpopular essays on the unofficial political religion of India. And this is a widely read book, especially by those who want to understand how secularism has effectively led to stifling of the space of the majority community in Bharat. I could have avoided raising the issue of religion altogether as far as this particular topic is concerned, and kept it very, very constitutional and kept it very, very academic. But I think it would defeat the very purpose of this particular topic if I don't discuss religion as part of a discussion on secularism and the impact of secularism on national life as well as religious identities in this country. The empirical evidence that I would actually collect to prove my point is the number of schemes which were run in the name of specific religious communities at the time of the introduction of the Constitution, or the coming into force of the Constitution in January 1950, and the number of schemes that are actually run by various state governments as well as the central government in the name of certain specific religious identities, particularly religious minorities. And I would ask myself, if the government is so keen on doing away with religion as the basis for policy making, and doing away with the role of religion in public life, or at least in administrative life and in constitutional public life, how can the government continue to mouth these kind of platitudes, all governments on the one hand, and continue to facilitate and encourage specific schemes for entitlement and benefits in the name of religion? So the statement of, let's say, commitment to secular values is at loggerheads with the conduct of the Indian state in creating mechanisms which specifically further religious identities, and where religious identity effectively forms the basis of schemes or of beneficial schemes. So what are the three layers that I have introduced so far? Before I go to the topic further, let me just introduce these topics. One, there is a clear Christian theological nexus between the concept of secularism and which underlies the concept of secularism. And therefore, when we try and impose European notions of secularism as part of Bharatiya national life, we must ask ourselves, how is this justified? Is such an understanding of secularism even relevant to Bharat? And assuming that we actually want to live by the European style of secularism, then Bharat must have the right to effectively adopt for itself a specific religious identity and continue to promise equal rights of propagation and practice to other religions. Nobody has accused England of being an unsecular state or an anti-minority state. Nobody has accused Germany of being an anti-minority state or an unsecular state. Nobody has accused Sweden of being an anti-minority state and an unsecular state, despite these states having very specific policies recognizing the state religion and having state sponsorship of specific religion, namely Christianity. And yet when Bharat seeks to effectively recognize its civilizational roots and its civilizational origins, and when it tries to recognize that there may be a lot of people in this country who follow faiths which have not originated in this particular country, that doesn't mean that I am supposed to abandon my identity. At the same time, it doesn't mean that I am bound to be unjust to them and treat them unfairly. When I have specifically recognized rights as part of Part 3 of the Constitution, namely fundamental rights, which gives them the right to practice their religion equally at par with members of the native religions, how can I still be accused of being anti-secular when I'm merely saying, merely because you are practicing certain faiths in this country, I don't need to abandon, or I don't need to wish away or ignore or pixelate the faith of my ancestors? That's the basic question that Bharat has to effectively ask today. And we have been beating around the bush on this particular question for the last 73 years for want of clear articulation or for want of conviction. Therefore, I have taken it upon myself to ask these questions, building on the works of several stalwarts and building on the works of several geniuses, to basically ask this question: how long will India continue to pussyfoot around the question of religion in the name of secularism, when the fact remains that religion has played such an important role in its national life in the last 70 to 73 years? Every aspect of national policy making, from let's say population control to monogamy to uniform civil code to abolition of polygamy, effectively raises the question of religion. In such a situation, what is the point of running away from religion? There is no way that Bharat can run away from this particular concept at all. The framers of the Constitution have identified this and have spelled it out on the floor of the Constituent Assembly on a regular basis, that the lifeblood of the national life of Bharat is religion. And therefore, to turn this particular country into an anti-religious state or an irreligious state or a godless state, so to speak, goes against the grain of its history. That doesn't mean that India has no space for atheists or atheism. India has a lot of space for practice of any kind of, let's say, conscience. In fact, if you look at Article 25(1), it doesn't necessarily speak of the right to practice religion, but it speaks of the right to practice and profess your thought and conscience, which means you can either believe in a religion and you have equal rights not to believe in a certain religion. But now secularism itself has acquired the status of an unofficial religion, wherein it has become the touchstone to test everything. I don't think this country, especially Bharat, given its peculiar history, given the bloody history that it has been witness to, needs to necessarily adopt a militant version of secularism, where religion has to be done away from all aspects of life and all facets of life, because there is a direct nexus between Bharat's native faith systems and its civilizational identity. Therefore, tomorrow, assume for a moment, if any person holding a public office decides to start a certain ceremony or a certain function with a Saraswati Vandana, he is not necessarily religious. He is effectively to the notions of this civilization, wherein you pay obeisance to the goddess of knowledge before you start a certain knowledge-based activity. So the controversy that surrounded the invocation of the Saraswati Vandana during the Atal Bihari Vajpayee regime in 1998 and between 1998 and 2004 is proof of the fact that we have ingested this nonsense of militant secularism without understanding that there is not a single country that is completely following militant secularism. Perhaps there are countries like France which can make that particular statement. But France has taken a position even with respect to the burqa ban, saying that this is against the notions of France, this is against the values of France, this is against the values of equality, fraternity, and let's say brotherhood, so to speak, that France effectively celebrates. So France at least is clear that when it comes to militant secularism, it will criticize every religion equally and will not necessarily accommodate certain sentiments in the name of minority sentiments. And there are certain other European countries very openly religious in nature, which have a religious character in nature. Bharat is effectively in a Trishanku status. It takes a position of convenience. Secularism as a concept is to be adopted only with respect to the majority religion, but when it comes to the minority religion, we must effectively fall back on the rights of minorities. And this is a very curious mix. It makes for a hodgepodge where you're not even consistent with the militant notions of secularism that you think Europe follows, which it doesn't. So neither are you close to France, nor are you close to Germany, nor are you close to United Kingdom, nor are you close to any of the Scandinavian countries. So what is the nature of secularism that Bharat effectively subscribes to? This is precisely why when the word secular was sought to be introduced in the constitution, opposition came from multiple quarters on the basis of lack of a specific definition for this particular concept and because of its vagueness. And therefore, secularism, it was anticipated, would become a tool for political baggage, for political mileage, and for political incentivization, which is exactly what has happened over the last 73 years. In fact, let me actually read certain portions from the Constant Assembly debates where Nehru has actually made a couple of statements. So let me just read it out. In fact, this is, I think, in the debate of 15th of November. Yes, 15th of November. In fact, the introduction of secular as a word to the preamble to the Constitution was proposed by Sri K.T. Shah. And this was opposed by people like Sri H.V. Kamath. And he made the specific statement. Let me just read it out, please, just a second. So sorry. I'll share the details with the members of the audience after the session is over. But precisely because of its inability to be captured in a specific definition, and because it is capable of being imputed multiple definitions, depending on personal proclivities or personal ideologies, so to speak, or political ideologies, so to speak, the word secular was specifically not included either as part of the preamble to the Constitution. The only place where it found reference in the original Constitution when it came out on the 26th of January 1950 is in Article 25(2)(a), where it has continued even before or even after. So let me just refer to Article 25(2)(a) to understand the context in which the word secular has been used in the Constitution at even before the 42nd Amendment of 1976 and subsequently as well. So in Article 25(2), it says nothing in this article shall affect the operation of any existing law or prevent the state from making any law regulating or restricting any economic activity, any economic, financial, political, or other secular activity which may be associated with religious practice. This is the specific context in which secular has been used in Article 25(2). And in no other provision of the Constitution did the word secular find reference. It was inserted in the preamble, and it doesn't even find mention in any other provision other than Article 25(2)(a). And yet somehow every discussion around the Constitution seems to revolve around this, let's say, this skewed notion and this abnormal creature called secularism. So my suggestion would be that so 73 years has given us a certain experience, which is that we have failed in concretizing a specific definition for this particular concept, nor have we been true to its European origins, nor have we been true to the French model, nor are we true to the English model. So what is this peculiar Indian model? The peculiar Indian model effectively has had the consequence of adoption of appeasement politics. And appeasement politics is not a word that is found mentioned for the very first time in independent India. The accusation of appeasement was specifically to be found even in the Constituent Assembly debates, to basically say, if you wish to promise fair treatment and equal treatment to members of the minority communities so that they are not shortchanged because of their religious identity, it is still possible to do so by giving them express rights without necessarily falling back on the notion of secularism. So therefore, the argument that was being made was rights under Article 25 are equally available to all religions. Rights under Article 26, which speak of the rights of religious denomination, is equally available to all religions. Then you have Article 27, which effectively says that the state shall not sponsor any particular faith. Then you have rights under Article 28, 29, and 30. And under Article 30, you have specifically recognized the right of linguistic and religious minorities to maintain cultural and educational institutions. So having given them very specific rights to ensure that the rights of minorities to maintain their places of worship, to maintain their way of life, to maintain their language, their script, their culture, and their religious institutions, and their right to actually manage educational institutions. What is it that secularism is meant to achieve over and above these rights? When specific rights have been given to secure the interest of all communities in the country, and there is absolutely no discrimination on the basis of religion, and the language of the Constitution makes it abundantly clear that no particular community has more rights than other communities. In fact, perhaps there are special rights that are given to minority communities to ensure that their lack of numbers never comes back to haunt them in their ability to run their own institutions. What is the purpose that is served by this concept of secularism? If the object is X and that object is achieved by specific provisions from Articles 25 to 30, what is that X plus plus object that secularism is meant to achieve? This remains unclear till date. Therefore, my suggestion would be that we either remove the word secular from the preamble so that this discussion and this politically motivated discussion that seems to hijack every discourse of this country is done away with, and there is no constitutional basis for this particular discussion. And we limit the scope of the discussion to express rights guaranteed to communities under very specific and express provisions of the Constitution. So if anybody wants to make an argument with respect to minority rights, let them make an argument on the basis of Articles 25 to 30 of the Constitution, where there are very specific provisions and there is an enumeration of what is available and what is not available. The state's power to interfere with the rights of religious communities and their practices and their ways of life is equal. It is not as if the state has more power to interfere with minorities than with the majority. And if the history of the Indian state is any proof, then the fact remains that the Indian state has interfered more with the ways of life of the majority community, more with the religious practices and beliefs of the majority community than with the minority community. Therefore, what is the need for an argument to be based on secularism when the constitution has given very specific pegs which are sufficient to cover and secure the interest of all religions, including and especially minority religions? This is a question that I think that merits a very specific answer, because tomorrow we will have all sorts of specious and untenable arguments and unsustainable arguments being made on the basis of secularism. If tomorrow I wish to effectively present the facts of history and how multiple places of worship were demolished in the name of religion or in the name of a certain way of life or in the name of certain faith systems, then I will be asked to not present even that particular history before the next generation, citing some weird and skewed notions of secularism. So it is my suggestion that if we want to abide by the constitution, the fact remains that even in the absence of the word secular in the preamble, the constitution was no less secular between the 26th of January 1950 and 1976. And the constitution and public life have only mired themselves in greater religious discourse and religious strife only after the introduction of the word secular in the preamble, because it has allowed a lot of people to drive a wedge between communities in the name of secularism, because they pursue religion-specific policies, religion-specific entitlements, and religious-specific vote banks in the name of secularism, which has had a direct impact on national life, on national integrity and unity. So here is a direct instance of a constitutional amendment having changed the course of public discourse and changed the course of national discourse in Bharat from 1976 to 2020. So it is my opinion that perhaps we need to start revisiting this. And this discussion would be completely truncated and ahistoric without reference to how we have blindly imported a Christian notion of secularism into Bharat, and to the detriment of Bharat's own indigenous faith systems, to Bharat's own civilization. This, I think, is the broad theme that I wish to present. Given that this particular subject typically incites a lot of questions and attracts a lot of questions, I would prefer to actually take a lot more questions at this particular stage. And as and when I need to make a few more points, I will do that in response to questions. But I think the introduction to the topic at this particular stage, I've covered it sufficiently. So, Vikas ji, I would suggest that we start taking questions.
In fact, I've written after 5:50. This is by Raj Srivastava. Meanwhile, the question will start coming. He says, historically speaking, Bharat has always been
a dharmic civilization.
Or a dharmic civilization. However, at a point when democracy was not functioning in the Republic, the Western concept of secularization was imposed on the sacred land of the East without even defining the word. So, what are the damages that we have already faced because of secularism? And if we want to become a civilization state, how can we think of considering the fact that secularism in the constitution?
So, in response to Mr. Raj's question, let me be clear that it is my position that the brand of secularism that we observe today in Indian national polity is directly at loggerheads with the civilizational values and civilizational identity of Bharat. And second, Article 1 of the Constitution makes it abundantly clear that India is used as a synonym to Bharat, and Bharat is a reference to the civilizational heritage of this particular land. Therefore, for all practical purposes, Bharat is an Indic civilizational state as recognized by Article 1 of the Constitution. Therefore, I completely agree with you that secularism, as professed and practiced in the absence of a very specific definition, is at loggerheads with Bharat's Indic civilizational and constitutional identity. I have no doubts in my head on that particular issue. Let me introduce another concept where there is sufficient scholarly literature which effectively points to the fact that the concept of secularism has been used to the detriment of non-Abrahamic faith systems and indigenous faith systems and indigenous practices across the world. And there are enough books on this, and there is enough literature on this particular issue. Let me try and also share the details of another author, the classical age of Christianity, destruction of the classical age by Christianity. Let me just share that, where there is a very clear reference to the use of secularism to the detriment of other communities. So this book is called The Darkening Age, The Christian Destruction of the Classical World. And this particular book is written by Catherine Nixie. And I have had the benefit of reading this particular book, and I'm still in the process of reading this particular book. And scholars outside of India, scholars of decoloniality, scholars of race studies, scholars of civilizational studies, and scholars of constitutional studies have come to the conclusion that secularism is a Judeo-Abrahamic concept, and its application in non-Christian societies and predominantly non-Christian societies has had the effect of killing the visibility and the presence of native faith systems and native cultures from public life altogether. I'll give you a simple example. In fact, I think about 2 or 3 weeks ago, a short clip of the Chief Justice of India prostrating in a temple before the deity was circulated on Twitter and on WhatsApp to basically say, how can the Chief Justice of India fall at the feet of a deity in a temple when India is a secular state? This was the very specific question asked in relation to that particular tweet, or in relation to the particular clip. The Chief Justice of India is a practicing Hindu, and his designation as the Chief Justice does not require him to abandon his faith. And he was prostrating in the private confines of a temple in his private time. So today we have come to a stage where the practice of faith by public functionaries, even in private, is sought to be stifled in the name of secularism. And where does this particular notion of secularism have any kind of support in any portion of the constitution, or in any interpretation of secularism, is unclear. So secularism has become a weaponized tool to effectively guilt trip the majority community, and especially public functionaries who happen to be practicing Hindus, into abandoning their faith, into abandoning their visible symbols of religion. Let me also make a blunt statement. Nobody asked Sri Manmohan Singh to abandon the visible symbols of his faith the moment he became the Prime Minister. Nobody asked him to do any of those things, and they could not have as well, and they should not have as well. Because merely because he occupied the post of the Prime Minister, which is a secular position, it doesn't mean that he was expected to abandon his own faith and abandon his own belief in his value systems. He was entitled to practice his religion as a devout Sikh and also hold the position of a Prime Minister, and there is no inconsistency between the two. Today it has come to a point where the obligation of secularism on the state translates to people who occupied let's say secular positions to even abandoning their own faith systems. And unfortunately, this particular expectation is cast on members of the majority community, not even members of the non-majority community. So clearly, secularism has acquired a certain weaponized hue, a weaponized edge, as a consequence of which its effects are intended and targeted at one particular form of identity, is what the empirical evidence says. It's not my opinion. The evidence clearly says that secularization of Indian life has resulted in the destruction of and continuing destruction of one particular form of identity, and one identity alone and nobody else. While religious autonomy and religious profession and wearing of religious symbols is encouraged when it comes to non-majority communities, when it comes to the majority community, the expectation is that in the interest of minority sentiments and at the order of secularism, they are supposed to sacrifice all visible symbols of their culture, civilization, and religion. There is absolutely no proof for this, and there is absolutely no basis for this in any canon of constitutional law, in any canon of a civilized society. This is very, very peculiar, and this happens only in Bharat. Next question, please.
Mr. Deepak, it is by Manas Jha. He said, the question is, how will India justify the removal of word secular from the preamble, and on what basis it can be legitimized?
If there was no specific reason given to introduce that particular word in 1976, why should a reason be given to remove it? I don't understand. We can always make the statement that the word secularism has effectively led to communalization of politics and public life in Bharat from 1976 to 2020. And given that Bharat was no less secular between 1949, 1950, and 1976, when the word was introduced in the preamble, no further justification or clarification needs to be given for its removal. In fact, the Keshavananda Bharati judgment came out on the 24th of April 1973, and that particular judgment speaks of the word secular and secularism in the absence of that particular word in the preamble. So look at the timeline. Constitution comes out on the 26th of January 1950, and the Keshavananda Bharati judgment comes out on the 24th of April 1973. It recognizes secularism as as part of the basic structure of the Constitution. Then where was the need to add the word secular further in the preamble in 1976? When the judiciary has recognized the concept of secularism as part of the basic structure of the Constitution, where is the need to actually introduce it further? Then people might say, if it is already part of the basic structure of the Constitution, what is the harm if it remains in the preamble of the Constitution? An express presence in the preamble of the Constitution has led to constitutional harakiri, has led to constitutional chicanery and constitutional fraud, according to me, wherein the word, its presence in the preamble, is constantly cited to vitiate public life and is constantly cited to create turmoil in political discourse in India. And therefore, that word needs to be removed altogether so that people can discuss facts, people can discuss opinions without relying on some vague notion of secularism. It makes really no sense to base opinions and to base our policies on some vague notion and amorphous form of secularism, which nobody is able to wrap their heads around so far. Next.
This is by Naveen Kumar. Similar debate surrounded Article 15, Subclause 3, when the state was allowed to make special provisions for women despite Article 15(1), barring discrimination on the ground of sex. It has also become a political tool. Special provisions were to be provided when there is a manifest inequality and not a routine phenomena. Actually, this debate is also connected with the right of equality. No fundamental rights are unconnected with others. What is your take on this?
See, if somebody invents a knife, you can use it to dice vegetables and you can also use it to murder people. And gun can lead to protection and can lead to gun violence. So the weaponization of Article 15(3), or let's say the canons of equality enshrined in Article 15, is no reason to do away with those provisions or away with our belief in the fundamental notion of gender equality or gender justice. I think this is an issue which needs to be addressed at the level of the judiciary, because you see, whatever the legislature is bound to do is open to multiple interpretations and it can be weaponized by vested interests, especially those people who are interested in weaponizing legitimate causes such as feminism will always find ways and means to weaponize everything in the Constitution. The better thing is for the judiciary to dismiss frivolous PILs which approach the court and which are academic PILs only for the sake of publicity, only for the sake of vitiating the atmosphere, and only to give the impression that India is fundamentally a patriarchal society and anti-woman society. When PILs are filed with these kind of motivations and they are backed by powerful entities and powerful groups and powerful clubs, so to speak, then it becomes the job of the judiciary to ensure that such frivolous and nuisance PILs are effectively nipped in the bud and they're not given any further credence at all. So I don't think the solution lies in watering down the scope of rights which are given in the Constitution to protect gender justice, to ensure that there is gender justice and to further the goal of gender equality. So I will certainly not support the watering down of any provision in Article 15 or any sublim of Article 15. I think the solution there lies in the position that the judiciary takes with respect to frivolous PILs. Frivolous PILs have effectively become the bane of the Indian judicial system at this point of time. Right from animal sacrifice to whatnot to temple entry and every issue, people think that it's perfectly available for them to approach the court in the name of gender justice, in the name of animal cruelty and whatnot, and effectively try and guilt trip that institution into taking that issue seriously, because otherwise headlines will say something else, news debates will say something else. That is effectively what has become as far as the manner in which PILs are filed and entertained is concerned.
This is by Vinod. Did anyone contest 1976, the amendment which you are talking of? If so, what is the status? If none contested, can we still file bill to contest the same?
See, 75 to 77 was the period of emergency. And those who opposed Mrs. Gandhi at that time were pushed behind bars. Okay. So, in terms of opposition, uh, Mrs. Gandhi's primary justification was that the Janata Party and a coalition of parties were effectively fascist organizations which were out to destabilize the country. And since Congress is effectively the fount of all that is secular, and Congress is the guardian of secular values in this country, it effectively became a justification for introduce the word secular as part of the preamble. Frankly, I don't think she had any constitutional basis for what was introduced, and I don't think there was too much of an opposition in terms of, let's say, effective opposition. There was opposition perhaps on the streets, but certainly not in the parliament. Look at the period between 1975 and 77. A host of amendments were introduced without any kind of debate or any analysis at all. So what was the second part of the question? What were you saying?
If not, can we still challenge it?
Yes. So several articles of the Constitution continue to be under challenge, especially the ones that were introduced with respect to right to property, Article 39. They are the subject of a 9-judgment challenge. So there is nothing wrong if the word secular is challenged as part of a petition and its introduction in the preamble is challenged before the Supreme Court. In fact, from what I remember, the news reports actually point out that the word secular and socialist, both of them have been challenged as part of the preamble. A petition is lying before the Supreme Court at this stage.
That is what Ayushi Mishra has also pinpointed in the chat.
Right, right.
It says, should the government of its time try to change the preamble, or should it be, or would it be better for a lawyer to move to the Supreme Court against this 42nd Amendment?
I don't think it makes sense to approach the judiciary for everything, for the simple reason that any matter before the judiciary is like a coin toss in the air, and one can never be sure of the outcome, and one can never be sure of what could be the reasons for arriving at a certain conclusion. If it is possible to address some of these issues at the legislative level, then there is no reason why we must not address it at the legislative level. So look at it. I'm clearly saying that on issues with respect to PILs and on issues with respect to Article 15 and weaponization of Article 15, the solution lies with the judiciary. But when it comes to express provisions of the Constitution which are on the face of it problematic and which are capable of blatant misuse, and there is proof of blatant misuse, it is better to actually leave it to the legislature to do it. Because if you ask the judiciary to do it, then it's not just the outcome, but also the reasons that come with it, which could create another Pandora's box. So the better thing is for the legislature to repeal the amendment made through the 42nd Amendment to the Constitution.
Is this selective application of right of freedom of thought and expression also a violation of right to equality as well as secularism? How do you think this should be encountered? This is by Harish Sharma.
I don't think I got that question very clearly, sir. Can you repeat that?
Just hold on. Meanwhile, I will read another question. How can people be okay with provisions being provided on the basis of caste, that is reservation, because they were persecuted on the basis of caste, but have problems with provisions being given on the basis of religion to another group because the basis of their persecution was religion?
So here's the answer. If the position is that people who have been persecuted on the basis of religion must necessarily be entitled to reservations, I will buy that particular argument. And therefore, the Hindu community must be the subject of reservations, because I don't think history points out to the fact that any other community has effectively been the subject of persecution here. So I'm perfectly comfortable with that argument. Let Hindus be given reservation because they're effectively the persecuted community. Fair enough. I really don't have a problem. And if you take a look at my public positions previously, I've said that caste-based reservations must continue as long as there is caste-based persecution. I've never actually taken a position different from that. However, if you want to give reservations on the basis of religion to say that people have been persecuted on a religious basis, perfectly fine. Then Hindus must get that particular reservation. I don't think anybody else is entitled to
that. Before taking one question, because a lot of people are asking, yes, this not only this webinar, but all webinars are being uploaded on our channel of Beyond Law CLC. So those who want to see this particular session or previous ones, they can always subscribe, share, and like Beyond Law CLC. We will be uploading this particular session also, and the present session is also live on the Facebook. This is, can Article 368 be invoked to substitute secularism with dharma if we gave the proposition that dharma is the product of Indian civilization, like Magna Carta is for US. This is by Manat Singh.
In fact, it's a fantastic suggestion because this suggestion is backed by one of the suggestions made by Sri H.V. Kamath as part of the Constituent Assembly debates, as well as Sri Lokanath Mishra, specifically pointing out that Bharat's allegiance over and above all is to the concept of dharma, and dharma is not to be equated with religion, because while these days when we refer to the word Hindu dharma, we have converted this into religion. The fact remains that it specifically refers to the moral, righteous conduct which is subscribed to by, let's say, adherents of dharmic faiths, so to speak. Therefore, I think it's perfectly justified if secularism in the preamble were to be replaced with the word dharma. There is enough precedent for it, or there is enough justification for it in the Constituent Assembly debate, and there is nothing wrong at all. According to me, Bharat's constitutional morality and Bharat's national life is predicated on this fundamental doctrine of dharma, and there is enough basis for it in the Constituent Assembly debates.
This is by Pranshu Kamra. He says, do we need to abolish the word secular, or we need to use it correctly? What is your insights?
See, as much as possible, we must stick to those words which are capable of defining or being defined with some level of clarity. And those words which have certainly attained a certain degree of notoriety are best done away from the Constitution. And when there are indic replacements, such as dharma for the word secular, I might as well use that particular word, because you see, language makes all the difference and terminology makes all the difference.
What do you think about Article 295? No, this would be. How do we deal with the inclusion of secularism in the basic structure? This is by Daman Trivedi.
How can you include, sorry?
How do we deal with the inclusion of secularism in the basic structure?
The concept of secularism in the basic structure would have continued, as I said, even without any problem. The thing is, so let me address this in a slightly different way. The judiciary and Indian legal system has typically understood the word secularism in a slightly different way. Perhaps what can be done is to equate it with our notions of fair treatment and equal treatment of different faith systems. Let me give you a better example. In fact, I think the answer to this lies in Article 26. So what is the answer? Article 26 effectively recognizes the right of religious denominations of all faiths to be able to manage their religious affairs, to be able to manage their educational institutions, to be able to manage their properties, so on and so forth. Of all the countries in the world, the one country where Article 26 is extremely relevant is Bharat, given the sheer diversity of funds and sheer diversity of sampradayas, and also sheer religious diversity. So once you have Article 26, which ensures a fair degree of autonomy and a fair degree of, let's say, distance from the state with respect to all communities, secularism, as far as Bharat is concerned, is defined better by Articles 25 to 30, and you don't need to trace it beyond that. So there are two options available. As one of the participants effectively suggested, replace the word secular with dharma in the preamble, or remove the word secular altogether. And if you wish to understand India's commitment to secularism, use express provisions of the Constitution and not the preamble of the Constitution. Therein lies the answer. To the extent that everybody has the right to practice and propagate their faiths and manage their institutions within the four corners of Articles 25 to 30, that is the limited extent to which Bharat is required to be constitutionally secular. Bharat need not abide to a higher standard of constitutional secularism over and above what is expressly provided in the Constitution.
This is by Deepika Sharma. Even if the word secularism gets removed from the preamble, there is still other articles 25 to 30 available to defend the ideas of liberals. Do you think it is just a matter of word, secularism, or anything else?
See, there is a huge misnomer about, or let's say there is a huge misconception about whether Articles 25 to 30 give more rights to minorities, and therefore they further this skewed notion of secularism. I have recently written in the Open magazine an an article specifically addressing this particular issue, that constitutionally speaking, minorities do not have more rights than the majority. In fact, what has been given in the constitution is an express recognition of the very same rights available to the minority as is the majority. So there is an article that I wrote on the 17th of, sorry, just a second. I'll just share this article so that people can read it, where I've addressed this issue in very clear detail, citing certain judgments of the Supreme Court. So there's a judgment of the Supreme Court, namely TMA Pi, wherein the court was looking at the right to manage educational institutions. And in that particular judgment, the court clearly comes out to the conclusion that minorities do not have extra rights compared to the majority to manage their educational institutions. Both communities and both sets of groups have the same set of rights. What has made a difference is not a judgment of the Supreme Court or the provision of the Constitution. What has changed this particular balance is the Right to Education Act. Okay. The Right to Education Act, which is a consequence of the 93rd Amendment to the Constitution, effectively says that obligations under the Right to Education Act shall apply only to majority community, and minority educational institutions shall be exempt from the obligations under the RTE. That change that was made to Article 15 of the Constitution and through the 93rd Amendment is the single biggest amendment which has altered the amount of rights and the scope of rights available to majorities and minorities. Otherwise, until then, a 9-judge bench or perhaps 11-judge bench of the Supreme Court was very clear in its view that minorities do not have extra rights under Articles 25 to 30. I've just shared the link. Can I make it open and share it? Just a second, please.
What you can do is you can share it with me on the WhatsApp. I can share it on the WhatsApp group of Beyond Law.
So I've just shared it with everyone. So this is the link to the article which I wrote on the 29th of May 2020. And the title to the article is Divided by Religion, and where I've identified the mischief committed and caused by the 93rd Amendment and how the law until then recognized everybody as equal before that. Plus, I've also raised about 6 to 7 questions at the end of that particular article. Let me just read out these questions because it is perfectly consistent with the theme of this particular debate. The first question that I've asked is, if Article 30 mandates a state-to-state determination of linguistic and religious minorities, what justifies the continued existence of the National Commission for Minorities Act 1992, which empowers the central government and not state governments to notify as to which communities constitute minorities? So my basic question was, the Supreme Court has interpreted Article 30 to the extent of saying that the status of a minority is not based on the proportion of population at the national level, but at the proportion of population at the state level. If so, the concept of Hindu minorities in non-Hindu majority states must equally be recognized, both in the Northeast as well as in certain other union territories, such as even Kashmir. The second question that I have raised is, what justifies the continued existence of notifications dated the 22nd of October 1993 and the 27th of January 2014, under which, under the National Commission for Minorities Act, the government of that particular time notified certain communities as national minorities, such as Muslims, Christians, Sikhs, Buddhists, Zoroastrians, and Jains. So if the Supreme Court effectively takes the position that you must always identify minorities on a state basis, not only did the government come out with the legislation to recognize national minorities, it also came out with specific notifications recognizing the concept of national minorities, which goes against the Constitution. Then my third question was, when the Constitution recognizes linguistic minorities and cultural minorities, why is it that the National Commission for Minorities recognizes only religious minorities? So today, the word minority has been limited in its application only to religious minorities, when clearly that has no basis in the Constitution. My fourth question was, what was the basis for the creation of National Minority Affairs in 2006? And why hasn't the post of Minister of Minority Affairs seen any diversity in appointments since 2006? That means adherents of only one faith have occupied the post of the Ministry of Minority Affairs since 2006. Question number 5, why is there no representation of linguistic or cultural minorities in the National Commission for Minorities? These are 5 to 6 questions that I've raised as part of this particular article. I would request people to read this article and share it as widely as possible, because it exposes the hypocrisy of secularism that is practiced in Bharat.
You can also share it with me on the WhatsApp, and then we can share
Yeah,
it.
I've just shared the question on the group as well. Yes.
Yeah. Your questions have already come.
Yes.
As long as conversations are about false pride based on mythology, will Bharat ever develop, according to him?
I don't know what is being referred to as mythology here, but I do agree with the sentiment that as long as we have discussions based on incorrect versions of history or completely fabricated and concocted history, there is no way that Bharat will ever move on, because Bharat will continue to build its policies and make its policies based on notions of history which have been put together by cultural Marxists or by the white man and not by its indigenous scholars.
This is by S. Jyoti. What should we do as citizens to get secularism out of
the preamble? See, frankly, what I would suggest is you must expose state governments in their conduct and even government at the center. If you believe that, okay, let me answer this in a slightly different way. Every government, regardless of which party it belongs to, feels the need to come out with a report card showing how many thousands of crores have been spent in minority welfare schemes and minority beneficial schemes. Why is this important? Why does every government, regardless of which party is in power, feel this need to actually do this? So on one hand, you want to say that we must unify people, and on the other hand, you constantly divide people by tangibly allocating resources specifically on the basis of religion, without any rational basis, without any empirical basis. When it comes to caste-based reservation, the one thing that the Supreme Court has said is that you must undertake a study to understand whether a certain community is backward, whether it lacks in representation in public office, or whether it lacks in representation in state employment, and then come to the conclusion that reservation is important. But no such study is even ever undertaken with respect to minority schemes. From Tamil Nadu to Kerala to Andhra Pradesh to every state possible, there is always a reservation in the name of religion, and which everybody seems to be perfectly comfortable with. So my suggestion would be that if governments don't listen to the grievances of people which are legitimate and constitutional in nature, then each of these schemes must necessarily be challenged in a court of law on grounds of violation of constitutional principles, and specifically even the notion of secularism. Secularism itself is violated if you start coming out with schemes in the name of religion without giving a sufficient justification for it, without giving sufficient data-based evidence for it.
Can we replace India with Bharat? And if yes, then what are the steps that can be done?
Article 1 already says India, that is Bharat. Replacement may or may not be necessary. It is not sufficient to replace India with Bharat. You must think of India as Bharat, and what would that translate to? That you recognize the history of this land, you recognize the identity of this land, and you recognize that the history of this land does not let us treat any minority unfairly on the basis of religion. I've said this any number of times. In fact, I think there is a participant, Mr. Trishul Modi, who says that as a Parsi, why am I not being treated as a minority? Why do I not get the same kind of treatment? My clear response is, Parsis in this country came at a time when Bharat was not even a secular republic, when we did not even have a constitution. And so far, nobody can accuse Bharat of having ever persecuted Parsis. They were persecuted by the Arabs when they effectively threw out the Parsis out of their own land, and they were pushed into extinction, or they were effectively pushed out of their own land into exile. Bharat has never done that. And as Modi rightly points out, Mr. Trishul Modi rightly points out, the fact remains that Parsis, who constitute perhaps the super minority in this country with a population of barely 60 to 70,000, don't figure in our discussions on minorities anywhere at all. That's surprising. So even when it comes to minorities, we are clearly committing the clear act of discrimination between different minority communities. That is the fact of Bharat's skewed brand of secularism. How many more questions will we take, sir?
We can take, I think we will take 3 more or whatever is your call. If you want 2, I can stop at 2.
3 is good, sir.
Okay. It is to you specifically. He says, you often talk of India as civilization state, but what are the specifics? This is by Vineet.
So if Vineet says that I often talk of India as civilization state, I'm assuming that he's been following my work. So my suggestion would be, kindly read the 15 series article articles that I have written under the column called Indic Views as part of the Daily Guardian, where I've clearly explained why Bharat is a civilizational state, drawing elements from India's history as well as from India's constitution. Again, let me share the link to that so that people know that even if they want to argue with me, they will need to specifically cite my pieces against me. And I don't say anything for which I don't have any support. So here is the piece. So let me just share it publicly. This is the link to my series in the Daily Guardian. I have made out a case for why Bharat is a civilizational state in this particular piece, in about 15 to 16 pieces. Do yourself the favor of reading it before you challenge me on this particular proposition. My answers are laid out in those articles.
This is by Hanat Singh again. Can you point out some articles in the Constitution that reflects the essence of the concept of dharma?
Right. So again, I have written another piece effectively highlighting that the use of the word public morality in Articles 25 and 26 are effectively references to dharma, and there is support for it in the constitutional debates again, where Dr. Sarvepalli Radhakrishnan has said that as far as Bharat is concerned, morality is dictated by dharma. In fact, Swami Ranganathananda, one of the former heads of Ramakrishna Mission, his definition of dharma was cited by the Supreme Court in certain judgments to understand the meaning of morality as used in the Constitution. So I think it's important to read judgments. It's important to read a bit more of literature. People seem to be holding a lot of opinions without actually doing the reading. You can't shoot opinions from your hip to basically say that my opinion is a decent substitute for fact. I think there is more need to read, and there is enough in the public domain in the day of age and in the day and age of internet for you to read on all of this.
I will ask, Avneet has timed again posted the question, but somehow so many questions and takes have been coming up. I will ask him to post the question and one more question.
Yeah.
This is a suggestion to you. Please try to be more active on Instagram and YouTube so that you can reach more and more youth. This is a suggestion to you. He says that your suggestion ipso facto will not further the case like you are saying. He says that you should also go.
Fair enough. Okay. I can try. Despite my limited time, I'll do my best.
Kinds of literature you would recommend to read for understanding about Indian civilization?
So the one thing that I've done as part of the series in the Daily Guardian is that I have identified books, I have identified authors, I have very clearly identified the sources so that people can read and understand how Bharat is actually an Indic civilizational state. So in fact, in the piece that I have done, I have written what I have established is, when the Indian national movement specifically chose to make a case for Bharat's independence, the first question that came from the Britisher was, how can you ask for independence when you have never been a single political unit ever in your history? What is your basis for actually asking for independence of Bharat as a single political unit? So several historians started writing books specifically on the question of why Bharat has the right to function not just as a civilization, but also as a single political unit. Those books and excerpts from those books I have specifically cited as part of my pieces. Kindly take the trouble of reading those pieces. I'm sure that even if you disagree with me, you will have a better basis to disagree with me after having read those pieces.
That would be good, because they say that it's always better to agree, but may not. You may disagree on a point of view, but one should also have a reasoning to agree also.
Right.
Avnish, this ultimately, Bharat is an Indic civilization society. Why haven't we, in our opinion, been able to accept our civilization history? Rather, we have followed the other religions to hijack our culture, history, and civilization heritage, so as to speak, despite having numerous necessary provisions in the constitution. Shouldn't we have an official religion based on our history, because Indic civilization was always all-inclusive?
The answer to all of this lies in education, because education's primary job is to introduce children in their formative years to the roots of this land, to the culture of this land. And we are hoping to find all our answers in the legal basket, or the judicial basket, or the constitutional basket. But unfortunately, we don't seem to pay enough attention to education. If schools teach children that Hinduism in India has always only been about cows, caste, and about killing women or widows, then how on earth do you actually expect them to come out with a positive impression of this particular country? Nobody has exposed them to books by Swami Vivekananda or Sri Aurobindo or by Lala Lajpat Rai or by Swami Shraddhanand, by Arya Samajis, by non-Arya Samajis, by so many people who have defended the culture of this particular land and who have defended in the face of hostile aggression from multiple quarters, all forms of aggression. So you cannot hope to understand issues of national interest and issues of constitutional interest without sufficient grounding in history. And you can't hope to understand history unless and until it is part of our textbooks, because nobody seems to have the patience to read beyond 500 words or 1,000 words. I'll tell you the constant trouble that I face. If I come out with a video of 30 minutes, I am being told, sir, nobody has the patience to watch for 30 minutes. Come out with a video of 5 minutes or 10 minutes so that we can circulate it on WhatsApp. If I write a piece for 1,000 words, then they say, where is the justification for it? You must write a detailed article. When I write an article of 3,000 words, I'm said, sir, 3,000 word kaun padega? Sir, itna time to kisi ke paas hota nahi hai. So the problem is fundamental laziness and apathy, where people find all sorts of excuses to not do enough reading when everything is out in public domain. ना वीडियो देखने के लिए पेशेंस होता है, ना आर्टिकल पढ़ने के लिए पेशेंस होता है. पेशेंस सिर्फ इस चीज के लिए होता है कि 5 मिनट की वीडियो जो व्हाट्सएप में सर्कुलेट होते हैं उसको देखो और सर्कुलेट करते जाओ. That's what we have effectively become. So as long as this remains our approach to serious issues, I don't think how we hope to learn better.
The way you express that people are not satisfied, the way you sometimes you say that writing more words, a bigger video. I'm reminded in the childhood times in the schools where there was a story that father, son, and the donkey, they were all three going together, and ultimately, if you recollect, many of would be recollecting that ultimately the donkey had to be thrown in the well, and the father and son, instead of going on the donkey together, had to walk their way. So the moral of the story was that suno sabki, karo dil ki.
Right.
Or you hear everyone, but it is way that you want to put it across. You have to, as they say, that you have to read actively and passively, and then ultimately, as a lawyer, conclude what is right and what is the way to move forward. Right. That could be my take on that aspect. I think we have taken a lot of questions, and thank you, Sai Deepak. As we, at the first brush, we had said that it should be an illuminating session. You have actually shown a right path, as they say, that even a light, a candle at the right end of the tunnel can show the brightness in its own way and can carve out the path. I think there are certain takes during this entire webinar which will help us to move forward and think forward. And they say for a pragmatic thinking and pragmatic moving, you have to take what I said at while I was taking and giving insights about your aspect was that assimilate all the facts, think, and then move forward. Correct. They say that the process of life and thought process is just like a traffic light. Stop, look what has been commented upon. Yellow light is to pause whether it is correct or whether it have a retroactively you think and move forward. And then green is that whatever you feel right, you should move forward. That's the way of moving life. Right. And on the day of independence, I would believe that one should have all independent thoughts. Accumulate all the thoughts, but ultimately, as they say in law also, that you have to funnel them in the right direction, the right perspective, whatever you feel right. Those who have been following us, they can continue to follow us. Those who have got connected for the first time, you can subscribe, share, and like our YouTube channel of Beyond Law CLC, where all those webinars will be posted. And you can also share and like our Facebook page, Instagram page, and on LinkedIn, and you will get the updates. Tomorrow, in our pursuit to these webinars, which we have started conducting during these testing times, tomorrow we will have Justice K. Abraham Matthew, former judge of Kerala High Court, speaking upon documentary evidence, primary and secondary evidence. So do stay connected with us. We are having forthcoming this entire week as what was done in the previous webinars. All insightful sessions from the persons who have immense knowledge. As we all stated at the first instance that Mr. Deepak is not only an articulate lawyer, but he is also an erudite speaker, as we have all seen. Thank you for all of you, those who have stayed connected with us. Stay safe, stay blessed, and happy Independence Day once again. And thank you, Mr. Deepak, for giving us an illuminating session akin to what your name actually belongs. Namaste, Jai Hind.
Thank you for the opportunity. I'm very, very grateful for over 150 people for patiently listening to everything that I've said. My only request would be that the way forward is knowledge, knowledge, and knowledge alone. And as someone who rarely has the time to read as much as I want to, the one thing I can confidently say is that the biggest invention for the current generation is the internet. And there is so much of material that is publicly available that even if your textbooks don't teach you what they're supposed to teach you, there is enough out in the public domain for you to read. So it's a question of what you use the internet for and what you search it for. So you can search it for all sorts of controversies, or you can actually search it for knowledge and arm yourself. The choice is entirely yours. So if I am able to do this with my limited knowledge, and the fact that I'm merely repackaging what I've read and I'm sharing it with people, people with better insights and better IQ can perhaps come out with even more original opinions and path-breaking thoughts. So kindly do yourself the favor of reading as much as possible. That is what will ultimately help you present your opinions in a much more lucid fashion, and to also support it in the face of opposition. I don't think confidence comes from the number of people who effectively hold your views. Confidence comes from the fact that even if the rest of the world is arrayed against you, are you in a position to defend your position without necessarily having to fall back on support for numbers? That's the true test according to me. Thank you.
Before parting, Mr. Deepak, I will just ask, since you have given the insights that one should read a lot, I will ask that what suggestion will you give, because there is voluminous books, internet, all. So how do you suggest that one should do active reading so that one could actually gauge what would be the right? Because sometimes while even moving around in the net, etc., sometimes your attention gets diverted. How do you get more focused, and how do you read more faster than, and also to gather them within your mind? What is the way forward for that?
Sir, frankly speaking, this was a question that was asked to me once. So I can share with you what I follow. I don't know if it is universally acceptable. What I do, I can share. So one is, at least in our profession, I think the art of cross-pollination is extremely important, which is you don't just read what is useful, but you should know how to use what you have read. Okay, that's more important, which means as a lawyer, at the very least, we are expected to have a fair understanding of economics, a fair understanding of history, a fair understanding of logic, a fair understanding of philosophy, and of course, a very clear understanding of the law. This cross-pollination effectively has led to a point where I think anybody who aspires to be a rounded lawyer has no other option but to read voraciously and as diversely as possible. So that is from the standpoint of a lawyer. But then how do you manage that in the time that you have? One, your personal life certainly takes a hit. That certainly happens. So it's a question of how much you want to push yourself and what is it that you wish to do. Two, I believe very strongly in not making notes based on what I read. Because when you decide to make a lot of copious notes on the basis of what you read, it slows down the pace of reading, and automatically you dumb down your mind's ability to grasp as much as possible. So I've come across a lot of people who believe in making lots of notes based on one book, and they will be stuck with that one book for several months because they've not finished making their notes. And when you ask them what is it that you have actually made of a certain book, their ability to assimilate specific points from the book and present the saransh of the book completely sucks, because they've effectively forgotten the forest for the trees. So the one thing that I started doing effectively was read a book and read one book at a time and start making book reviews, so that you're in a position to present the overall tone and tenor of the book, perhaps in about 2 weeks or 3 weeks. And you have the ability to comment on the big picture as well as the very specific aspects which the book has presented. Now it has come to a point where I'm comfortable reading multiple books on different tracks and different subjects, and I'm able to connect them as much as possible. In fact, I'll just share one brilliant article that I read on this particular subject, which is of use to everyone. It's called Deep Literacy, the Dying Art of Deep Literacy. Let me just share it with you. Deep Literacy. I'll share that article with you, sir. Yes, The Erosion of Deep Literacy. This is a fantastic article that was written in National Affairs earlier this year in January 2020. In June 2020. It's a fantastic article on how people are gradually losing the ability to read even one book at a time and finishing it in good time. So I think the basic thing would be that we avoid, let's say, switching from one page to another, which is what the telephone effectively has done, which is what the mobile phone has done. That we open multiple pages and we don't realize that it has a serious effect on our ability to retain stuff, our ability to focus on one thing at a time, and it creates attention deficit disorder, according to me. So go back to the basics. And going back to the basics would mean when you start a book, you don't read it in a piecemeal fashion. You finish it cover to cover, end to end, no matter what. And the more you start doing it and the more you start reading diverse stuff, I think the mind is structured in such a way that it automatically starts forming subconscious patterns, and you will be in a much better position to correct aspects of civilization and politics to law than you are when you read stuff in isolation. So that the way forward is cross-pollination, diverse reading, and deep reading. When you take a particular subject, you need to ensure that you're in a position to speak on that subject at the most fundamental level possible, in the absence of any notes, in the absence of any file, in the absence of any aids. So that has been my approach so far, and I think it has helped me.
So the last call, because people would definitely ask, how to become more articulate?
Articulation, I don't think lies in mastery over language. I don't think it lies in mastery over English or knowing how to put together a sentence with pentasyllabic words. I don't think that is how you become better at articulation. I think clarity in content is the first step towards articulation, coupled with your own original thoughts. So the traditional Indian way of reading is you split it into two parts, Pathan and Adhyayan, which is you read first and then you contemplate on what you have read, so that you're in a position to come out with your own original views. So if tomorrow someone were to ask me to define something, I should be in a position to define it, and I must also be in a position to criticize the definition for its pitfalls, in the absence of which I have merely quoted what already exists, but I don't know if I have any original thoughts on the definition itself. So the ability to understand the concept in its bare bones format and also to comment on it with clarity and have your own original views on what is wrong, whether you agree with it and why you agree with it, I think is the way forward as far as articulation is concerned. Language comes much later. When there is clarity of thought in the mind, then somehow the tongue will manage to roll the right words out. And with practice, you will slowly be able to do that, let's say, with diverse topics. So one of the reasons that I try to speak extempore is to be able to ensure that I'm subjecting myself to the most withering scrutiny of possible, even in the absence of any tools to aid me, so that one, people know that when you ask me a question, you should be ready for the answer as well as a counter punch. So I will never come unprepared. Two, I'm very, very confident of what I say, and I'm equally confident of what I don't know. When I know for a fact that I don't have an answer to a question, there are any number of times that on a public platform, I've clearly said, I don't think I'm either in a position to answer the question or my knowledge on that particular subject sucks. So you should know what you know and what you don't know. Humility in admitting that there are certain subjects that you're not familiar with is very, very important. Otherwise, if you try to be an expert in everything, you will not be an expert in even one subject. So identify your core areas and keep hitting on it.
Thank you. So the point I can just sum up is that you say that you have to read extensively and intensively, and that is why the mind will think expansively.
Exactly.
Not expensively, but expansively.
Absolutely.
Thank you, everyone. Stay connected, stay blessed. And thank you once again, Mr. Deepak, for giving the insights on that too on a 15th of August on an Independence Day with the independent thought process, as you what said. You relook, revisit, and rework upon yourself before answering that. The insights given by you are actually encouraging for everyone on the platform as well on the Facebook, and those who will follow up us on the YouTube or the Instagram. Thank you.
Thank you. Namaste. Jai Hind.
Jai Hind.